You are sitting here in India, tomorrow you are in Japan, or you are trying to download a movie, the server of which is hosted in Kentucky. You are having an Airtel as a operator and you want to call up a friend who is using Vodafone. As a service provider, absolutely we find no trouble. There is no interoperability issue. There is no performance issue. And this is the value of a standard that we are talking about. This is the value of a technology that companies, or the few handful of companies that are now left, that we can actually count on our fingers, who have created best of the technology for all of us as consumers to use. What is the fight then? Why are we fighting? Why are we in the court? One of the reasons, as I said, that it's emotion versus a logic. Emotional pitch is never bad to speak or use, but it is absolutely bad to speak when somebody wants to delay the royalty payments or do not want to really come across the negotiation table and pay up. And why is that so? Why people don't want to pay? Because again, if you really look at the manufacturing size here, there are two set of people. One is the technology provider, the other is the only user of this technology. Hardly there is any investment in R&D. These are the new manufacturing units which have just opened up. More than manufacturing units, they are more the assemblers of these phones. So 80% of the phones that we carry in our hands is rather imported into the country. And I would rather agree with what Deepak just mentioned, that this leads to unwillingness, because there is no downside for the unwilling licensee to really come forward and negotiate. And the reasons are three. Number one, okay, patentee, you have put in a lot of cost. First of all, let them prosecute at the patent office. Let it take 4 to 5 years for the patent to get granted. Let's go through it. Then when they come to me, I'll make sure that they pant to an extent and breathe like a dog that will never show up whenever they call up. And even after that happens, they'll arm twist the patentee to an extent that he will be lured to go to the court and seek a relief. Okay, now we are in the court and we are defendant and the plaintiff fighting. It will take number of years, as Deepak and Sanjeev just mentioned. And even after, at the end of the day, after many, many years, if court decide not in favor of implementer and rather in the favor of a patentee, he will end up paying the same amount he should have paid many, many years ago. So there is no downside. For good 10 years, he has, have the interest, he has gained the market power, he has received the entire business, so there is no downside really. And second is the IP here in terms of essential patent. It's not like a vending machine where you put a money only, then you can take a product. It's an open garment store. You go inside, take a technology, go out, walk out, and nobody can really stop you, because the entire recipe to make a mobile phone or a chip or a technology is all available right on the SDO's website. You don't have to really go to the patentee and ask for a technology transfer. Whatever you need, it's all made available by the patentee up on the web right on the day one. I won't take much time because you know what court cases are happening and where we are, but I will just end by saying, I don't know how many of you have read biology during your schools, but there is an importance of earthworms. Earthworms are the system engineers. They are the ones who bring a lot of nutrients, who keep the nutrients of a soil intact. And if I can safely code these technology providers as the earthworms, they are the ones who have brought in the soul in the mobile phone. And unless they are there, you cannot see plants grow and trees grow, which is where we have Indian companies who were plants or seeds once, but they have grown up to a tree. And as a consumer, we won't be able to see the fruits as mobile phone unless we keep the entire ecosystem intact. So all I'm saying that I'm not against implementers or against or in favor of patentees. All I'm in favor of a balance, where patents are not kept close to my chest at any point in the day. At least come forward and negotiate. Thanks.
Thank you for that, Sheetal. And let me just, I will summarize very briefly some of the United States or North American perspective, and then we'll drill down on some of these issues across our panel. But in the United States, our patent law, of course, is embedded in our US Constitution. It's right there in our first article of our American Constitution that patent owners, one of the important functions of the patent system is to promote innovation, and that patent owners in exchange for publishing their information have the power to exclude others. So that power of exclusion is in our Constitution. The patent system to protect innovation and spawn innovation is in our Constitution. And one of the issues that we're dealing with in the United States is the balance between patent law and antitrust law, or as you call it, competition law, or as some parts call it, monopoly law. And the biggest occurrence in the United States, if I had to pinpoint a couple of key issues or trends in the United States, one is this identification of these two competing issues, patent law and competition law. And this is regulated in America by the agencies, the Federal Trade Commission and our Department of Justice. And there's a specific set of guidelines that those two bodies of our U.S. government put out. And the last time they put these guidelines out was in 1995, and they are referred to as the Antitrust Guidelines for Licensing Intellectual Property. They came out in 1995 before anyone even talked about standard essential patents. And so they've been on the table this past year. So the current issue in the United States is what is these two commissions, or the Federal Trade Commission and the Department of Justice, what are they going to do about these guidelines for licensing? And are they going to modify the guidelines to address the standard essential patent questions that have been raised globally? Well, they've just put out in August of this past year, in 2016, a draft set of guidelines for updates to the 1995 guidelines. And in those most recent draft from the Department of Justice and the Federal Trade Commission, they did not specify anything about standard essential patents or FRAN licensing. They left it completely off the table. I personally think that's a good thing. I think it's good because standard essential patents and the rights that are associated with them really aren't different from other patents. And everything is associated with intellectual property rights is about negotiation. It's negotiation of the innovators with the standard setting organizations. It's negotiation of the innovators with the implementers and so forth. So we don't really, in my opinion, need special rules to deal with SEPs. And I think that's reflected in this most recent set of proposed updates to the FTC and DOJ, Department of Justice guidelines. So that's the hot off the press information. Another trend in the United States that's really significant, I think, is that for the first time in 10 years, we've been seeing a pendulum move in favor of strengthening IPR. We're seeing more expansive rights in terms of what is patent eligible. Computer implemented inventions, for example, are now swinging back to where there's more favorable treatment in the patent office. So we're seeing better drafted patent applications focused on computer implemented inventions, and biologic inventions are finding their way now through the patent office again, which they had been stopped for, our famous cases of Alice and Myriad and so forth. So that's a good thing. The last big trend that I'll refer to is, of course, the changing administration. In a very short period of time, another week, we're going to have a new president. There's no question about it. We're going to see changes in our administration of the patent system. And those changes are going to impact directly on what comes out of the patent office, the quality of the patents that are issued, the processes that are addressed within the patent office, such as post-grant proceedings and so forth, the quality of those proceedings, the interaction of the U.S. Patent Office with the courts, the appropriate amount of oversight between the two. We've seen, I think, with the past administration, some attention to patent quality, but in my opinion, not nearly enough. And I think that with a greater focus on innovation, technology, and so forth, and the meaning of what it costs to innovate, with more recognition of as Sheetal was saying, there's so much investment in technology, so much investment, and courts and many in the public don't realize, who are outside of the innovator's space, they don't understand how much cost goes into innovation. There's trial and errors, there's products that never make it to market. That doesn't find its way into damage calculations, but it's an incredible expense on the innovators. So I think we are going to see with a new administration, like it or not, you may like the Trump administration, you may not, but I think one good thing that will come out of the administration is more attention to quality of patents and a continuing trend toward protection of innovation within the United States, which should then make it easier for exchange of technology through licensing activity when you don't have to question the validity or integrity of the IPR. So that's a snapshot of some of the US issues. I think now what we'd like to do is turn to some specific issues on SEP FRAND, since we have a really fantastic panel here, and as you've witnessed now, very knowledgeable panel. We did have, as our first topic, just talking about the pros and cons of standardization, because some people believe that standardization maybe isn't a good thing, and others do. She'd already addressed that, so I think to some great extent the incredible value that standardization brings. So I think to address my colleague's insightful comment, we're going to move to a more substantive issue of royalty base issues. And of course, one of the big issues is component versus device and what is the appropriate royalty base. I'm going to ask Sanjeev, if you wouldn't mind, to lead us off in this conversation, and then I'll ask the rest of the panel to weigh in on that one.
Thank you, Patrick. And this is an interesting issue. And in fact, what Deepak and Sheetal said and what Stephen also brought this to the fore, essentially it comes to the frank terms, the reasonable rate of the royalty, if you look at that. Because even what the courts in India or courts in US or the UK or the European court have tried to address, including the antitrust bodies or the competition body, they have tried to ascertain the reasonable rate of royalty. But what is the root, where is the root of all this? Let us understand firstly in the 3-4 sentences, what is a standard essential patent? There is nothing called a standard essential patent. These are essential patents, and when a patent becomes essential, let us try to understand this fact. When an innovator company they came across certain innovation, certain patents, which they believe could be potentially essential to a standard. So potentially, even they are not sure whether they are essential or not. They put those patents in the pool to the standard setting organization. When those patents are thrown in the pool as an essential standard patents, at that point of time, even the patentee is not aware that all the features of that patent will read over to the standard. Only in the subsequent the period of time, it may be considered as an essential to that standard. Now, thereafter, the bargain has to happen, and that is not a very smooth or easy process. It is a very complex process. And then there will be licenses, and there are certain terms between few implementers and the many implementers who might infringe. And then the matter goes to the court. In most of the cases, not only in India, but across the globe, what we have seen, either China, UK, Europe, or US, the court determination has always brought down the rate of royalty in relation to a particular portfolio of SAP or a singular SAP. In all the cases, the rate of royalty has been brought down substantially. In one of the Chinese case, the InterDigital, where the royalty rate was put by the Competition Commission was 0.019%. Then we need to understand whose role is the primary role, how one should ascertain whether it is the duty of the court to begin with, as Deepak said, how the innovator should chase the implementer. Sheetal mentioned it takes a hell lot of time to get a patent and then negotiate. At the same time, the innovator should have some incentive. There should be some incentive for the future R&D, future innovation, and in that context, in my personal opinion, the burden lies heavily on the innovators, some burden on the standard setting organization, to begin with when they are pouring the patents in the pool, to suggest these are the reasonable royalty for this. Because let us see the chain. You have innovator, you have a network player, and then you have implementers who are only simply purchasing or buying the chip or importing the chip to manufacture handset. So there are chip manufacturers, there are network players, there are handset manufacturers. A handset manufacturers or the manufacturers who only assembles the handset and they sell under their own brand. They may not be aware that what kind of patents goes into making those chips. So there is some kind of unawareness among certain category of implementer